Good morning. Current state of the labor laws, Section 240, is the pendulum swinging again. Well, I'll talk about the pendulum. I'm going to go I gave Lisa some extra time because I find what she has to say always very interesting. So I'm going to go through this quickly. One reason is I went through the registration list, and I see most of you are from defendants' firms or carriers, and I know most of the firms, and you deal with these issues every day. Correct? Yes. Okay. I have to apologize for my dark glasses. I was dreaming of Mo Levine last night. And, that's for Henry, because he's probably the only one here who remembers Mo. One thing we can, regarding the pendulum, one thing we can all agree upon as plaintiffs or defendants is that the law under Section 240 is constantly evolving, and what very well may be current today won't be current a year from now. In fact, cases we were talking about last year may not have the same precedent that they did at that time now. In fact, last year I brought a couple of course books that I was involved in construction accidents. One is from personal injury litigation under the Safe Place to Work statutes, moving from the 80s into the 90s. Personal injury litigation, work-related injuries, the dialogue of the 90s. And I said, these are about as useful as the field code. No, Henry, you remember the field code repealed in 1938, fact pleading? You remember you had to write those long complaints? And okay, they were good things to put on your bookshelf, but there was no point to reading them. Not so anymore. What I'm going to do, because there's not that much time, and you have Brian Schutz, and I wouldn't call it an outline, it's a treatise, and it's worth the price of admission to get it. And he goes through all of the areas of labor law in detail. Due to limitations of time, I'm going to focus on the recalcitrant worker sole proximate cause defenses, because I feel, and I think many of you will agree, that this is an area of the labor law which shows the pendulum swinging back and forth. Regarding these defenses, there's no question that from the late 1970s through the early 2000s, the decisions clearly favored the plaintiffs. And just a little bit of history, very little bit. In 1978, the Court of Appeals decided Hames versus New York Telephone Company. It's discussed in detail at page 441 of the course book in Brian's treatise. And listen to these facts. And some of you may recall them. The plaintiff's decedent was killed when a ladder upon which he was standing fell. It was conceded. The decedent owned the ladder. He set it up himself, had no help in doing so, failed to properly place it, and there was nothing wrong with it. Despite this, the defendant owner was held absolutely liable. And the person who wrote that decision was Jack Fuchsberg, who many of you may remember. And Jack, as you may recall, was a renowned plaintiff's trial attorney who always wanted to get on the Court of Appeals, and he finally made it. Right, Henry? The thing is, we all know that these decisions are judge-oriented. They depend upon the particular bench that's sitting, and that's why this pendulum is swinging. When Governor Pataki was elected, we had a lot of appointments of more conservative judges who interpreted 240 and these defenses somewhat differently, if you may say. I'd say a lot differently. Now, as I'll get into, Governor Patterson has been appointed governor, and the whole complexion of the courts both the appellate divisions and the Court of Appeals certainly have changed. You have Jonathan Lippman as the chief judge, and his views are much more liberal regarding the interpretation of labor law. You have other judges that have been appointed who also, Gene Piggott, who was a plaintiff's lawyer. So you have to view it in that context, just like you'd view United States Supreme Court cases. Last year, I said that a case that clearly shows the change in the labor law is an old Third Department case, Long versus Murnane Associates, which is at 443 of the course book. And it was decided by the Third Department in '79, and appeal dismissed by the Court of Appeals. The plaintiff was granted summary judgment in that case as a result of a scaffold collapse. And the plaintiff, there was no question about it, he improperly erected the scaffold. And he was ordered by his employer to correct the condition which the employer considered to be dangerous prior to the accident. And he said, yeah, sure. And then he never did. And he wins, okay? And I said that under Blake, and I'll talk about Blake very quickly because we all know Blake. Under Blake, that case would have been tossed. The plaintiff would have been out of court. I'm not so sure of that today, a year later. And that's because this pendulum, you have to view the labor law as a pendulum that swings. And if you look at it historically, I'm not so sure that would be the case today. Which brings us to the sole proximate cause. And as we know, the leading case on the sole proximate cause defense is Blake versus Neighborhood Housing Services of New York City, which was decided in 2003. It's discussed in detail at page 239 of the course book. Plaintiff, in that case, had set up an extension ladder, which he owned, used on a regular basis, testified the ladder was steady, it had the OSHA-required rubber shoes, was in proper working order, and what happened was, as plaintiff was working on the ladder, it retracted, and plaintiff was injured. And at trial, this case went to trial, so on appeal, there was no review of the facts of the case, but he testified he didn't know whether he locked the extension clips in place. And in affirming a defendant's verdict, the Court of Appeals stated this: here there is no comparative culpability, as the jury implicitly found the fault was entirely plaintiff's. The latter afforded him proper protection. Plaintiff's conduct here is negligence, was the sole proximate cause of the accident. Now, when I read this case, I said, wait a minute, negligence? What's that have to do with a 240 cause of action? How many of us always thought that contributory negligence was not a defense to a 240 cause of action? How is this any different than Hames? Or Long, same really basic facts. And I'll tell you what, it isn't. It's just the pendulum swinging, and it's the makeup of the court. It's what I like to call the pendulum effect. The way you've got to view Blake is this. You have to look at it as a misuse case. In short, if a plaintiff misuses a 240 enumerated safety device, he's going to either lose, or she's going to either lose on summary judgment, or depending upon the proof, there may be held to be a question of fact. Or so I thought last year. And Lisa and I are going to talk about a couple of cases at the end. This is the reason, and I see still people doing this, but this is the reason depositions and discovery in these cases are so important. It's certainly no longer enough for a plaintiff to go in and say, you were the GC, You signed the contract, ladder fell, bye, so long, nice to see you, and move for summary judgment. You can't do that anymore. And as a defendant, you can't give up anymore. You have a lot of areas now, as you all know, to question on and really nail it down as to whether indeed you can prevail on a sole proximate cause theory or on a recalcitrant worker defense. Now, most of you are from the defendants' firms, and the fact is, certainly over the last year, maybe a little longer, the recalcitrant worker defense has been totally subsumed by the sole proximate cause defense. And most of the motions I see, or people call me and ask me about, or the decisions I read, even though they involve workers who were allegedly recalcitrant, the motions for summary judgment by defendants are being brought on a sole proximate cause theory, and they're certainly being analyzed by the court in terms of the sole proximate cause defense. Now, there's a very important statement in Blake for both defendants and plaintiffs, which is imperative to understand. And it's now being used by courts and by plaintiffs, such as myself that I represent, to grant plaintiffs summary judgment or at least hold a question of fact. And that's because the pendulum is again swinging. If not back to where it was at the time Hames was decided, more to the middle. And I think any of us want, plaintiffs or defendants, we want some consistency. I want to know as a plaintiff, when I look at a case, what my chances of prevailing on it are. And as defendants, and I see a lot of the carriers' reps are here today, you want to know what figure to put on this, whether it's a no pay, whether this case has a value. And that's what we need is consistency. And I'm hoping, and I think the Court of Appeals will come down with some more consistent or precise rules that we can follow. But this is a very important statement in Blake. And the court stated, a defendant is not liable under Labor Law 240 where there is no evidence of violation and the proof reveals that plaintiff's own negligence was the sole proximate cause of the accident. Now, here's the crucial and critical language. Under Labor Law 241, it is conceptually impossible for a statutory violation which serves as a proximate cause for a plaintiff's injury to occupy the same ground as a plaintiff's sole proximate cause for the injury. Thus, if a statutory violation is a proximate cause of an injury, the plaintiff cannot be solely to blame for it. Conversely, if the plaintiff is solely to blame for the injury, it necessarily means that there is no statutory violation, which means that if a plaintiff proves that a scaffold, ladder, or other 241 enumerated device was not securely placed, etc., plaintiff's conduct cannot, by definition, be the sole proximate cause of the accident. And then again, depending on the proof, plaintiff will either win on summary judgment or there'll be a question of facts. And the courts have been increasingly using this language to grant plaintiffs motions for summary judgment, or at the very least to deny defendants' motions and say there's a question of fact. These cases are discussed in the course book from page 239 to 284 and page 458 to 779. The next important Court of Appeals case on the sole proximate cause defense is Montgomery versus Federal Express, which I'm sure you all know, decided by the Court of Appeals in 2005, discussed in detail in the course book at page 259. Montgomery is an aberration. And it's the courts, the appellate divisions are not following it. They're following Robinson. In fact, they're going back to older cases, but they're not following Montgomery. And as you may recall, the plaintiff was employed as a helper by an elevator company working under the direction of an elevator mechanic, and he was assigned to work in the motor room. And as those of you who have worked on elevator cases, the motor room is above the roof, and in this case it was 4 feet above roof level. The stairs that usually are there had been removed, and the plaintiff and his mechanic decided to turn over a bucket in order to reach the motor room. And how are you going to get down? Plaintiff decides he's going to jump. And the Court of Appeals affirmed summary judgment for the defendant, although there was no ladder in the immediate vicinity at the job site. Now here, listen to this. I don't know where they came up with this language. I never heard it before. Since ladders were readily available, there's no proof that plaintiff knew that, by the way. Since ladders were readily available, plaintiff's normal and logical response. Now the court is becoming, getting involved in psychiatry, but the normal and logical response should have been to go and get one. Well, plaintiffs choose to use a bucket to get up and then to jump down. That's the sole proximate cause of the injury. See ya, goodbye, out of court. Where does that language come from? It was not, I'm telling you, this never was stated in any case before. What about the fact that ladders were not in place at the work area? And what about the fact, and this is from the case, there's nothing in the record that plaintiff even knew ladders were readily available. 5, 6. Okay, I'm trying to move it along. You can see how fast I'm speaking. He's telling me I got 2 minutes. Lisa's telling me I have 6. Who would you listen to? I'm Mr. DeLisa. She'll give me the notes, okay? Keep the notes to yourself. Third important Court of Appeals case, and this is, I think, much more important than Montgomery in light of the way Montgomery's been sort of ignored, as many of you know, is Robinson versus East Medical Center. And basically in Robinson, the plaintiff had been using a 6-foot ladder to install structural beams. He was in an area where it required an 8-foot ladder, and it was conceded that 8-foot ladders were available, and plaintiff told the supervisor he would need one, and the case is tossed. This defendant's motion for summary judgment is granted. All of these cases are fact-specific, but here's what you can take from Robinson and use, certainly as a defendant, and you have to be aware of it as a plaintiff. 1, plaintiff knew he needed an 8-foot ladder. 2, he knew 8-foot ladders were on the job site, and furthermore, he knew where they were. 3, he routinely got tools for himself out of the tool shed. He wasn't told by anybody he had to get this job done immediately, and he previously, on other days, had waited for a ladder to be freed up before doing his job, and he had asked for an 8-foot ladder an hour or 2 before the accident. So Robinson makes a lot more sense than Montgomery, and Robinson is the case that's being followed. very quickly. How much time?
You have about 2.5 minutes.
Okay, 2.5 minutes. Okay, the recalcitrant worker case, it's defense in 2.5 minutes. And by the way, I had nothing to do with deciding how much time anybody would have. It's him. Listen, prior to 2004, the leading cases on the recalcitrant worker defense were 5. 1 Fourth Department case, Smith versus Hooker Chemical, and 4 Court of Appeals cases, Gordon versus Eastern Railway Supply, a 93 case, Hagens versus State, also Court of Appeals 93, Stolt versus General Foods Corp., and Jastrabisky versus North Shore School District. These cases are in the course book at pages 290 to 295 and 444 to 447. They're now becoming more relevant, so you should know about them, because the courts are, I have to do this quickly, courts are not really following Cahill versus Tri-River Bridge and Tunnel Authority that strictly. They're going back to the older cases. You're seeing them citing Stolt and Gordon and Jastrabisky. The old rule was, and it's really more and more becoming the rule again, was for a defendant to prevail on a recalcitrant worker defense. This is from all the cases I'm taking them. 1, there had to be a refusal by a plaintiff to follow a direct, immediate order not to use the device. 2, that the accident was contemporaneous in time with plaintiff's refusal, and that safe and appropriate safety devices were available. Now, I'm done. Not really, but he says I am, so what am I going to do? But I'll stick around all day. Wait, I'm not done with everything. Lisa and I have a discussion now, don't we?
You have 3 minutes.
No, you cut me down the time.
Can we have 10? Howard, can we
5
have
minutes.
10?
5 minutes. That's all we can do.
All right, listen.
Talk a little bit about Jerry.
All right, I'm going to skip Collins. Take a look at a case.
All right, you want to talk about it?
No, don't worry about it. Take a look at Collins versus West 13th Street Owners Corp. It's at page 472, and it talks about the plaintiff made his scaffold himself, one of these makeshift scaffolds, and defendants moved on the sole proximate cause defense to dismiss it. The court granted plaintiff's motion for summary judgment. The defendants claimed, wait a minute, all the materials to make a proper scaffold were available. Court rejected that argument and said that puts the onus on the plaintiff, which is not proper under the labor law. And it goes back to the Gordon case, actually, and because Montgomery certainly put the onus on the plaintiff, and so did Robinson, although Robinson I can understand more. But this case is indicative of this trend by the courts and the swinging of the pendulum to interpret Blake and Robinson more restrictively and to return to the precedents prior to Blake, which put the onus to provide proper safety devices on owners and GCs. Now, I guess we'll have to skip those and go to Cherry. You want to talk about Cherry?
No, you talk about Jerry, but may I add one sentence about Collins?
Yes.
In terms of Collins, I think the court is saying or suggesting that you can't ask the worker to actually go out and put something together, even though on most work sites, workers are often the individuals who assemble scaffolds, who erect ladders, who put things together. But they're suggesting that if you put the onus on the worker to do that, there's a violation of the law. I think it's another example of the pendulum swinging from more pro-defense to more pro-plaintiff under our new chief judge and some of the newer appellate division judges that have been appointed in the last 2 years. And you're going to see more of that. Before we get to Cherry, may I just mention that one recent case that came down, the latter case?
Very quickly, because Howard's getting very angry with me.
Oh, Howard, don't get angry. All right.
Doesn't bother me.
Just,
He's always angry.
Come on.
okay, just very quickly, this is a case where I actually wrote the brief but didn't argue it, and the First Department on December the 3rd said that a worker who was climbing down an A-frame ladder with objects in both hands and fell, and by the way, you're not allowed to climb down with objects in both hands because you're supposed to have 3-point contact with the ladder at all times, was not the sole proximate cause of the accident. This is Picano versus Rockefeller, and this is in the line of several recent cases that have come down attacking the use of ladders. Another one was Vukovich, which was from April of 2009, 61 AD 3, 533, where an electrician was electrocuted and fell off the ladder, and the court found that that was a violation because the ladder didn't provide proper protection to the worker. In these cases, the court is saying that the ladder, even if it may stand, is not enough. It's suggesting that other devices may be necessary. I've never found an expert that has said that there's another device that might be necessary or useful in connection with an A-frame ladder, which is essentially self-securing. But the the First Department has said, oh yeah, you need to have it lashed or held or chocked. It just doesn't make sense. But I think it's another example of the pendulum swinging back towards plaintiffs. I lectured with a lot of trial lawyers about 6 months ago, plaintiffs' lawyers, and they were talking about a movement to try to say that ladders never provide proper protection. Well, I think the First Department is helping them.
I don't think that's so correct, but I don't have time to argue. I only argue with Hirschhorn. Listen, I just want to refer you to Cherry where it is in the course book because I do have to sit down, but it's Cherry versus Time Warner. Brian Shute discusses it at page 281, and we never looked at each other's submissions, and I discuss it at page 475, and we both do it in great detail because it's a case of significant interest because it's not only an example of the recalcitrant worker defense being subsumed by the sole proximate cause defense, but an example of the courts trying to reconcile the holdings in Montgomery and Robinson, and it's laid out pretty well in the court in the book. It's a 4-1 decision. Catterson wrote it for the plaintiff, for the majority, and McGuire wrote it for the defense, First Department. And I'll tell you, even as a plaintiff, if you really were going to follow the law, McGuire was right.
And I agree with that.
He was. He was right based on the law. He wasn't right based on the law that was before, but that's where we are at this point. And I'm sorry I don't have much more time. And
Thank you, Tony.
He's a lot bigger than I am. Thank you.